Hello and welcome to BYJU'S IAS. Welcome to lecture number 4 of Polity-based current affairs relevant for your prelims 2020. We have to cover a lot today. I hope you will stay with me throughout the session. Even if we are to extend the session by a few minutes, please stay with me. Let's get started. First up, Interstate Migrant Workmen Act of 1979. The lockdown was announced by Prime Minister Modi and it left millions of migrant workers in limbo, and lakhs of them traveled on foot to back to their villages. This is where this Act of 1979 becomes very important for your prelims examination. Let's look at the statements. Number 1, the Act was enacted to prevent the exploitation of interstate migrant workmen by contractors and to ensure fair and decent conditions of employment. Is this statement correct? Absolutely yes. Ensuring fair and decent conditions is very important part of this act. Please remember this. Statement number 2, the law requires all establishments which are hiring interstate migrants, all these establishments are to be registered. Most importantly, the contractors who recruit such workmen, they have to be licensed as well. This statement is also correct. But when we look at statement number 3, most of you would assume that this statement is wrong. But this statement is correct. What is the statement? Migrant workmen, they are entitled to wages which are similar to other workmen, and at the same time, they are entitled to displacement allowance. They're also entitled to journey allowance, and they're also entitled to payment of wages during the period of journey. All these statements are correct. So what is the question asking us? Which of the above statements are correct? D. All of the above is the correct answer. Let's look at another question, and this is where we will link it with what is happening in Mumbai right now. Riya Chakrabarti and Sushant Singh Rajput case. Riya Chakrabarti booked under NDPS Act, so you might expect a question on NDPS. Narcotic drugs and psychotropic substances, it was enacted in 1985 and it is the primary legislation for dealing with drugs, but not only for dealing with drugs, also their trafficking. This statement is correct. Statement number 2. Now, important thing about this statement is 2 individuals have been arrested in Sushant Singh Rajput case. They were arrested because they were in possession of 59 grams of banned substance. But this 59 grams of banned substance, it is viewed as a small quantity of drugs. So tomorrow, when their case would be taken up by the courts, they can be given immunity. All they have to say, we apologize. Now we are volunteering ourselves for drug de-addiction programs, and ultimately they will not be convicted, they will not be booked by the judiciary. This statement is very important. The Act has provisions for the court to grant immunity from prosecution to an addict who is involved in small quantity of drugs if they volunteer that we will go for drug de-addiction programs. Statement 2 is correct. Statement number 3, look at this carefully. The state government can add or omit from the list of psychotropic drugs or substances. This statement is incorrect. Not the state government, but the central government can. The central government can add, can omit from the list of this psychotropic substances. So which of these statements are correct? B. 1 and 2 only. Let's look at another question. Which of the following conventions have not been signed by India? Convention number 1, Convention on Access to Information, Public Participation in Decision Making, and Access to Justice in Environmental Matters. Why environmental matters? From tomorrow, for 3 days, we are going to have environment and ecology based current affairs lectures. Why? Because environment impact assessment, it has been changed by the government. So this environment issue becomes very important for your examination. Has this convention been signed by the government of India? No. Another convention, United Nations Arms Trade Treaty. Which of the above conventions have been signed by India? D. None of these conventions have been signed by India. So we understood the link of current affairs with convention number 1. But what is the link of current affairs vis-a-vis Arms Trade Treaty? Let's look at the context. The context is China has decided to join this United Nations Arms Trade Treaty, but at the same time, United States last year in 2019, it pulled out from this Arms Trade Treaty. You know, there are clashes going on between India and China on the line of actual control. But there is another challenge going on between United States and China. They are in a trade war. China has been imposing tariffs on US products, US exports. United States is also imposing tariffs on Chinese exports. So there is a full-blown trade war going on between China and United States. Although this trade war has been halted for some time, but there was this trade war going on between the two countries. And the biggest loser in this trade war is Huawei, 5G equipment manufacturer, something that we discussed in international relations-based current affairs as well. That's the link. Let's look at something else. Which of the following conventions have not been ratified by India? So we are not talking about which of the conventions have not been signed by Government of India, but we are talking about those conventions which have not been ratified by India. Number 1, International Convention for the Protection of All Persons from Enforced Disappearance. This is in the news because of Jammu and Kashmir. Human rights activists and others, they are claiming that people are disappearing in Kashmir. There is enforced disappearance happening in Jammu and Kashmir. Lots and lots of newspaper articles in international media as well. So this convention becomes very important for your exam. But India has not ratified this convention. Convention number 2, Convention Against Torture and Other Cruel, Inhuman and Degrading Treatment or Punishment. This is in the news because of the custodial torture and death we witnessed in Tamil Nadu, where the son and the father, they were brutally killed allegedly by the police. But India has not ratified this convention against torture as well. Riya Chakraborty case. Has India ratified single convention on narcotic drugs the year of 1961? Yes. So which of these conventions have not been ratified by India? C is the correct answer, only 1 and 2. Let's look at Article 253 of the Constitution. When we look at federal setup or the federal polity in India, where in federalism we have the center and the states, so the relationship between the center and the states is a very important topic for your examination. All these important provisions in the Constitution, they become absolutely important for your exam, and we hope to cover all these important provisions one by one. First up is Article 253 of the Constitution. You would know that Schedule 7, it talks about distribution of powers, union list, state list, concurrent list. All those subjects, all those items mentioned in the union list, only the Parliament has the power to make laws on those subjects. For example, defense, external affairs, communication, banking, insurance, citizenship. When we look at state list, states have the power, or the state legislatures have the power to make laws on any item mentioned in the state list. For example, law and order, police, agriculture, gambling. But if you notice this Schedule 7 carefully, it says in normal circumstances, the state legislature has the power to make laws on all items mentioned in the state list, only in normal circumstances. Which are these not normal circumstances where Parliament can make a law on state list? That is Article 253. What is this Article 253? If India, as a nation, as a country, it has to give effect to an international treaty, to an international convention, only the parliament has the power to make law on that subject, despite the fact that this subject may have been within the legitimate domain of the state legislature, despite the fact that this subject belongs to states under Schedule 7 of the Constitution, but India has to give effect to an international agreement, to an international treaty, then Parliament has the power to make laws under Article 253 of the Constitution. And that is how, in the year 2011, when India ratified United Nations Convention Against Corruption, and to give effect to this United Nations Convention Against Corruption, Parliament passed Lokpal Act. So Lokpal Bill was introduced in the Parliament under Article 253 of the Constitution because Parliament had to give effect to an international agreement, to an international convention. Another interesting thing, let's link it with current affairs. UAPA, Unlawful Activities Prevention Act, which was passed for the first time in 1967, which was amended in 2019 as well. This UAPA was introduced in the Parliament under Article 253 of the Constitution. Why? Because to give effect to United Nations Security Council Resolution of 1947. To give effect to this United Nations Security Council Resolution of 1947, Parliament enacted UAPA in the year 1967 under Article 253 of the Constitution because India had to give effect to an international agreement, treaty, or a convention. Let's look at another question. India had no legislation regarding narcotics till the year 1985. Is this statement correct? Absolutely yes. This act, NDPS, has never been amended since 1985. This is incorrect because 3 times since the year 1985, when this NDPS Act was enacted for the first time, it has been amended 3 times. So statement number 2 is incorrect. Which of the above statements are correct? A, only one is the correct answer. Let's look at another question. Which of the following is the theme for International Literacy Day 2020? And the answer is literacy, teaching and learning in the COVID-19 crisis and beyond. This is the theme of 2020 International Literacy Day. Let's look at another question. The first International Literacy Day was celebrated on September 8, 1967. This statement is correct. Literacy goals, now this is a very, very important statement. Literacy goals are a key part of United Nations Sustainable Development Goals and its 2030 Agenda for Sustainable Development. Both these statements are correct. Which of the above statements is correct or are correct? C. Both these statements are correct. Let's look at another question. Jus soli and jus sanguinis is related to which of the following? Now, what is jus soli and jus sanguinis? Jus soli basically means law of the soil. Jus sanguinis means law of the blood. And this is related to citizenship. How? For example, United States of America, they believe in this principle of jus soli, law of the soil. Whoever is born on the soil of United States, regardless of the nationality of the child's parents, the child is a US citizen. Why? Because they follow law of the soil. Whoever is born on the territory of United States becomes the US citizen. There is an interesting case. A lady from Hong Kong, she was pregnant and she boarded a flight, and while she was in flight, she entered into labor. There were some people who tried to help her to conceive, to try to help her to deliver the child, but she resisted. She said, first tell me, have we entered into the US airspace? Because she basically wanted US citizenship for her child. And as soon as the plane entered the US airspace, the child was born because United States believes in jus soli, law of the soil. Whoever is born on the soil of United States becomes the US citizen. India also believed in Yas Soli till the year 1987. Till the year 1987, whoever was born on the soil of India automatically became the Indian citizen, regardless of the nationality of his or her parents. It was only after 1987 that another condition was added. If a child is born, one of the child has to be an Indian. That means one of the parent has to be an Indian, only then this child can be an Indian citizen. That means after 1987, we believed in Jus Sanguinis, which is law of the blood. And in 2003, another change was made. A child born on the soil of India becomes the Indian citizen if one of the parent is an Indian and the other is not an illegal migrant at the time of the birth. So now India believes in and follows Jus Sanguinis, which is law of the blood. United States believes in Jus Soli. So Jus Soli and Jus Sanguinis is related to which of the following? It is related to citizenship. Let's look at another question. Which of the following best describes cancel culture? And what is this cancel culture? Let's say, for example, Kanye West. He was initially the supporter of Donald Trump. He once said that I'm a supporter of Donald Trump. And he also said that slavery, which existed in United States of America, it was voluntary, it was optional. So it was not something which was forced on the blacks. Whenever a celebrity makes such statements, people, protesters, they cancel that individual. That's what we call cancel culture. For example, you open your Facebook, you will see an advertisement of Flipkart. Brand ambassador Ranbir Kapoor and Alia Bhatt. Because of anti-nepotism controversy right now, anti-nepotism campaign launched on Twitter and other social media networking sites, there are people protesting against these celebrity kids. And that is why these two gentlemen also have been cancelled. So what is a cancel culture? Can be important for your examination. When a celebrity or public figure says or writes something or engages in an act that is deemed offensive and inappropriate by the public, is this cancel culture? This is the beginning of cancel culture. Implication of this is the people then uninstall an app because they are facing backlash on the social media. But the question is asking, which of the following best describes cancel culture? And the best definition is pressure tactics that are employed by social media warriors. And because of these pressure tactics, they force a celebrity or an individual's workplace to fire him or her for his inappropriate behavior. And that is what we call cancel culture. Let's look at something else. Trends in World Military Expenditure is a report released by United Nations, World Bank, FATF, Financial Action Task Force. No, it is released by Stockholm International Peace Research Institute. Let's look at another question. Amendment of the Constitution. Amendment of the Constitution is in the news because an amendment was made because of which one constitutional body was set up, National Commission for Backward Classes. And you will see a question on that body as well. But for the prelims examination, you must remember and understand the procedure, the process that is involved in amending the Constitution. And this procedure is mentioned where? This procedure is mentioned under Article 368 of the Constitution. Just understand this procedure and I'm sure you will not miss out on any question asked in your exam. What is the procedure? First, a bill needs to be introduced. What is a bill? Bill is a proposal. The proposal is to add a fundamental right. The proposal is to add a directive principle or delete a fundamental right. That's a bill, constitutional amendment bill. That means this bill proposes to amend the Constitution. Now this bill needs to be introduced in the parliament. But where? First in Lok Sabha or in Rajya Sabha? This can be important question for your prelims examination. this constitutional amendment bill can be introduced in either Lok Sabha or Rajya Sabha. You can introduce this in either Lok Sabha first and then in Rajya Sabha, or first in Rajya Sabha, then in Lok Sabha. But who can introduce this bill? Only a government minister or a private member of the parliament. This constitutional amendment bill can be introduced by a government minister, can be introduced by a private member as well. Anything. But does this constitutional amendment bill require previous consent of the President of India? No. That means a constitutional amendment bill can be introduced in either Lok Sabha or Rajya Sabha by a government minister or a private member without prior consent or approval of the President of India. And then in Lok Sabha, it requires special majority to pass. In Rajya Sabha, it requires special majority to pass. And when this constitutional amendment bill is passed by both houses of the Indian Parliament by special majority, then it is sent to the President for approval. Then it is sent to the President for his assent. Here, an interesting question can be asked. President normally has veto powers. Absolute veto, pocket veto, suspensive veto. When a constitutional amendment bill is passed by both houses of the Parliament and then sent to the President of India, what are the options available with the President? Can the President say, I'm not going to sign this bill? Can the President say, I want to send this bill back to the Parliament for reconsideration? No. President has only one option, and that is to sign this constitutional amendment bill. That means a constitutional amendment bill passed by both houses of the Indian Parliament by special majority. Once it is sent to the President, President has only one option, and that is give your assent to this constitutional amendment bill. That's point number one. Second important point, let's say for example, Lok Sabha passes this constitutional amendment bill, but Rajya Sabha does not pass this constitutional amendment bill. In this case, what happens? There is a deadlock. For an ordinary bill, to resolve this deadlock, there is a procedure called Joint Session of Indian Parliament. That means if there is a deadlock between one house and the other house on a particular bill, there is convened something called Joint Session of Indian Parliament. But this Joint Session of Indian Parliament is not convened for a constitutional amendment bill. That means a constitutional amendment bill has to be passed by both houses of the Indian Parliament separately, and there is no provision for a joint session of Indian Parliament or joint sitting of Indian Parliament. That's what you need to know regarding amendment to the Constitution under Article 368 of the Constitution. Let's look at something else. Article 249. What is Article 249? I told you that state legislatures have the power that you can make a law on any item mentioned in the state list. Clear? But only in normal circumstances. There is a circumstance where Parliament can make a law on an item mentioned in the state list. One thing that we discussed was Article 253, where Parliament can give effect to an international agreement. Another mechanism where Parliament is empowered to make a law on the state list, that is Article 249 of the Constitution. What sort of questions can be asked? Number one, Parliament can pass a law on any item mentioned in the state list only after Rajya Sabha passes a resolution by special majority under Article 249. If Rajya Sabha passes a resolution by special majority under Article 249, that means Rajya Sabha is asking the Parliament, dear Parliament, it is in our national interest that you please make a law on the state list. And when Rajya Sabha passes this resolution, Parliament becomes empowered to make a law on state list. That's Article 249. Another interesting thing is, what is the validity of this law passed under Article 249? The validity is 1 year. That means the law passed by the Parliament on an item mentioned in the state list under Article 249, the validity of this law is only 1 year. Can the validity increase beyond 1 year? Yes, for another 1 year. But then again, under Article 249, Rajya Sabha should pass a resolution, that too by special majority. This is Article 249 of the Constitution. Let's look at Article 250. During national emergency, what happens? Parliament assumes concurrent power to make law on state list as well. We are talking about center-state relations because in the times of COVID-19, there are various constitutional experts who are saying that our federal polity has been transformed into a unitary polity, a unitary constitution. This is where center-state relations plays a very important role in your prelims examination. We discussed Article 253, we discussed Article 249. Let's discuss Article 250. During national emergency, Parliament assumes the concurrent power. That means state legislatures also. They can also make a law on state list when national emergency is going on. But when national emergency is going on, Parliament also has the power to make law on a state list. But interesting thing here is, what is the validity of the law passed by the Parliament under Article 250? The validity is, as long as national emergency is in place, this law passed by the Parliament under Article 250 continues. As soon as national emergency is revoked, this law will continue for a further period of 6 months. Long story short, under Article 250, Parliament assumes the power that Parliament can make a law on any item mentioned in the state list because national emergency is in place. But what is the validity of this law passed by the Parliament under Article 250? As long as national emergency continues, this law also continues. But if the national emergency is revoked today, this law will continue further for a maximum period of 6 months. And after the expiry of this 6-month period, this law passed by the Parliament under Article 250, it lapses. Let's look at another question. Article 252 of the Constitution. If 2 or more states, they request the Parliament that please make a law on state list, then Parliament can make a law for those states under Article 252. This Article 252 was used when in the year 1976, 11 states in India, they requested the Parliament, please make a law on urban land ceiling. And then in 1976, a law on urban land ceiling was passed by the Parliament under Article 252. Similarly, on Wildlife Act, law has been passed by the Parliament when the states have requested. That means in Article 252, you may be asked, which of the following provisions are present in the Constitution under which the states can request the Parliament to pass a law on state list? And that article is Article 252. But one interesting thing here is, when states request the Parliament under Article 252 that you make a law on state list, it is as if the states are surrendering their powers. That means when the states are requesting the Parliament that please make a law on the state list, on the state subject, it is as if the states have surrendered this power to the Parliament. After that, Parliament may or may not give this subject back to the states. This is Article 252 of the Constitution. Let's look at another question. A new All India service can be created only by the Parliament by passing a Constitutional Amendment Act under Article 368. This is where most of the aspirants, they are confused. They believe that under Article 312, Rajya Sabha has the power to make a new All India service, to create a new All India service. Absolutely wrong. To create a new All India service, The power is only with the Parliament. A new All India service can be created only by the Parliament when Parliament enacts a Constitutional Amendment Act, that too under Article 368 of the Constitution. But Parliament cannot initiate this. Parliament cannot on its own create a new All India service. Parliament should be empowered to create a new All India service when under Article 312, Rajya Sabha passes a resolution by special majority, and through this resolution, Parliament becomes empowered to create a new All India service. So if there is a question in your examination, a new All India service can be created by which of the following? Resolution of Rajya Sabha? No. By an ordinary law passed by the Parliament? No. By an ordinance promulgated by the President? No. By the law passed by the Parliament under Article 368? Yes. So statement 1 is correct. Interesting thing is the second statement. Creation of an All India Judicial Service only needs a government notification. Is the statement correct or incorrect? If statement 1 says a new All India service can be created only by an act of Parliament, then this statement should have been wrong. But this statement is correct. Why? 42nd Constitutional Amendment Act. The year was 1976. An All India Judicial Service has been created. And this All India Judicial Service, Constitution says, should not have a judge below the rank of district judge. So a new All India service has been created by 42nd Constitutional Amendment Act in the year 1976, but this constitutional amendment has not been notified. That means the only thing government has to do, issue a notification, and that will create All India Judicial Service. So statement number 2 is correct. Statement number 3, the new National Education Policy, which we are going to discuss today, recommends creation of an All India Education Service. This statement is wrong. The new National Education Policy does not recommend the creation of a new All India Service on education. So which of the above statements are correct? B, only 1 and 2. Let's look at another question. National language. And there is this controversy in Tamil Nadu. Tamil Nadu always has this controversy over a national language, or Hindi specifically. The question is, do we have a national language? No. Constitution only talks about an official language. And according to the Constitution, what is the official language of the Union of India? The official language of the Union of India is Hindi in Devanagari script. According to the Constitution, remember this carefully. According to the Constitution, the official language of the Union is Hindi in Devanagari script. But the same Constitution says for 15 years, that means from 1950 till 1965, English will continue to be used as official language. But after 1965, English cannot continue. Hindi will be the only official language of the Union. But then there was this controversy. Protest in the then state of Madras, where people protested the imposition of Hindi language on the southern Indian population. And then there was a compromise. And the compromise was, the year was 1963. Official Languages Act was passed. This is very, very important for this year's prelims examination. Official Languages Act 1963. It is this law which says the official language of the Union is both Hindi as well as English. Constitution says the official language of the Union is Hindi in Devanagari script. There were protests in Madras, and then there was a compromise, and the compromise was Official Languages Act 1963. And according to this act, the official language of the Union is now both Hindi as well as English. One more thing, there is no time limit. Time limit in the sense, there was a time limit imposed by the Constitution on the continuance of English as the official language of the Union. And that time limit was 15 years. After 15 years, English cannot continue. But here, this Official Languages Act of 1963, it does not talk about any time limit. So forever and ever, both Hindi as well as English will continue as the official language of the Union. But what about official language of a state? Just two things here, and then this topic is over. Can state choose one, two, or multiple languages as its official language? Yes. But here is important fact. There is something called Schedule 8 of the Constitution, and Schedule 8 talks about 22 Indian languages. 22 Indian languages. Originally, there were 14 languages mentioned in Schedule 8. Now there are 22 languages mentioned under Schedule 8 of the Constitution. The question is, if a state has to choose its official language, is it binding on the state that you have to choose only those languages which are mentioned under Schedule 8 of the Constitution? Or can a state choose any language as its official language, even if this language is not mentioned under Schedule 8 of the Constitution? West Bengal, few years ago, chose Kurkh as another official language of West Bengal. Kurkh is basically a Dravidian language spoken by the tribals in Jharkhand. And this Kurkh is not mentioned in Schedule 8. So it is not binding on the state that you can choose only those languages which are mentioned under Schedule 8 of the Constitution. No, you can choose any language even if it is not mentioned under Schedule 8 of the Constitution as the official language of that state. And when there was this controversy on the imposition of Hindi in Tamil Nadu, in the then state of Madras, that is where interesting fact comes into play. Ministry of Home Affairs, it has various departments under it. One department is Department of Home, Department of States, Department of Internal Security, Department of Border Management, Department of Jammu and Kashmir and Ladakh Affairs. MHA, after the revocation of the special status for Jammu and Kashmir, one name of the department changed. Originally, one department under MHA was called Department of Jammu and Kashmir Affairs. This department name has now been changed into Department of Jammu and Kashmir and Ladakh Affairs. But one department under MHA is the Department of Official Language. Why? Because when there were protests in Madras and many other places in southern India, when there are protests that affects internal security, Department of Internal Security is under MHA. That is why Department of Official Language was placed under Ministry of Home Affairs. That's the link of current affairs. But interesting thing here is three-language formula. And this three-language formula is again in the news because of the new education policy of 2020. There is one statement mentioned in the new education policy, and which is this: the NEP, National Education Policy, proposes early implementation of the three-language formula to promote multilingualism from school level. And that is why Tamil Nadu Chief Minister, he is adamant that we are not going to implement this three-language formula. So you might expect a question on three-language formula as well. Very briefly, what is this three-language formula? When there was this controversy on the official language, Hindi as the official language of the Union of India, then there was this compromise, Official Languages Act of 1963. Then the central government decided, let's have a three-language formula. For example, if there is a southern state, let's say Tamil Nadu, there in the schools, we will follow three-language formula. That means the children will be taught three languages. Language number one, their local language, Tamil. Language number two, English. Language number three, Hindi. Why? Because Hindi can be made popular in those states where Hindi is not spoken. That's number one. What about northern Indian states? There also we will follow three language formula. One is the local language, which can be Hindi. Second is English. Third is preferably a South Indian language. So the idea was very beautiful. The idea was that in non-Hindi speaking states, Hindi can be promoted. In northern states where Hindi is spoken, these beautiful South Indian languages will also be promoted. But ultimately what happened? Tripura, for example, Tamil Nadu, for example, they said we will not implement three language formula. We will implement only two language formula, Tamil, local language, and English. And in northern India, where it was argued, where it was thought that a South Indian language would be taught, there Sanskrit replaced a South Indian language. So basically this three language formula, particularly in southern India, is not implemented that effectively. But now this national education policy, it has spoken about this three language formula again. It is proposing that we will implement this three language formula so that we can promote multilingualism from school level. That is why this can be important for your prelims examination. Let's look at something else. And this is very interesting question. Can you read this? What is written here? Is the screen visible? If it is not, I will read it. Under National Education Policy 2020, which of the following foreign languages are to be offered to secondary level students? That means in National Education Policy, at the secondary level, foreign languages can also be offered. When the draft of National Education Policy was released a few years ago, there was one language, Mandarin, which is the Chinese language, Chinese Mandarin. But because of the clashes along the line of actual control between India and China, Mandarin language has been dropped. Dropped as those foreign languages which are to be offered to students at the secondary school level. Which are these foreign languages which are to be offered to the students at the secondary level? You have no other option but to memorize all these languages. Which are these languages? Korean, yes. Japanese, Thai, French, German, Spanish, Portuguese, Russian, but not Mandarin. So option A, 1, 2, 3, 4, 5, 6, 7, 8 is the correct answer. This is very important question for this year's prelims examination, considering the fact what is happening along the line of actual control. Let's look at another question. Which of the following are extra constitutional bodies? This is where some people, some aspirants have confusion. What is a constitutional body? What is a statutory body? What is an extra constitutional body? All those bodies which are mentioned in the Constitution, they are constitutional bodies. For example, Election Commission, Union Public Service Commission, or Unpredictable Public Service Commission. These are constitutional bodies. Why? Because they are mentioned in the Constitution. All those bodies which are not mentioned in the Constitution, they are extra constitutional bodies. But within extra constitutional bodies, we can have a statutory body, we can have an extra constitutional body. Which is a statutory body? A body which is created by the act of legislature. Parliament or state legislature enacts a law, and through this law creates a body. That body becomes a statutory body. But there are other bodies also which are neither mentioned in the Constitution nor are they created by an act of the Parliament. They are created by executive resolution. Executive issues a resolution and the body is created. For example, Planning Commission, the erstwhile Planning Commission. It was non-constitutional or extra constitutional, non-statutory body as well. Because this body was not created by an act of Parliament, it was created by a government resolution, executive resolution. And when Niti Aayog replaced Planning Commission, this Niti Aayog also is neither a constitutional body nor is it a statutory body. It is an extra constitutional, non-statutory body. What is the question asking? Which of the following is or are extra constitutional bodies? Zonal councils, are they created by the Constitution? No. Zonal councils are created by States Reorganization Act of 1956. So they are created by an act of parliament. So they are not constitutional bodies, they are statutory bodies. Niti Aayog, is it a constitutional body? No. National Integration Council, is it a constitutional body? No. University Grants Commission, is it a constitutional body? So which of these are extra constitutional bodies? All of them. Because question is asking, which of the following are extra constitutional bodies? None of these bodies are constitutional bodies. So all these statements are correct, all of the above. National Integration Council becomes even more important. Why it becomes important? Because of UAPA again. When UAPA was enacted in 1967, I told you it was because India was under obligation. Because it had ratified United Nations Security Council resolution. It was in response to that UAPA was enacted in 1967. But National Integration Council recommended UAPA that we should create a law, enact a law to punish unlawful organizations. And it is also because of National Integration Council that a terrorist organization of Assam, ULFA, was banned. And that resolution was also passed by National Integration Council. Since Assam Accord is in the news, NRC is in the news, UAPA is in the news, National Integration Council is also important for your prelims examination. Let's look at another question, and this is very important. Very important because of the protests that we witnessed in different universities in India in the aftermath of the enactment of Citizenship Amendment Act 2019. We saw protests in Jamia, we saw protests in JNU, we saw protests in Jadavpur University, in West Bengal, in Hyderabad University as well. So universities are in the news, but are there few universities which are mentioned in the Constitution? Have you ever heard that there are some universities which are mentioned in the Constitution of India? Yes, there are. And which are these universities? Banaras Hindu University is mentioned in the Constitution. Schedule 7 of the Constitution of India, which talks about union list, state list, concurrent list. In union list, this university is mentioned. Aligarh Muslim University is also mentioned in Constitution. Delhi University is also mentioned in the Constitution. These are the 3 universities that are mentioned in the Constitution. So which are these correct options according to the question? C. All of the above. All these universities are mentioned in the Constitution. Let's look at another important bill, Transgenders Protection of Rights Bill 2019. What are the important provisions of this bill? And we will also briefly look at the arguments against this bill because this bill is very important for your examination. According to this Transgenders Bill of 2019, this bill defines a transgender person. Now, who is a transgender person? Whose gender does not match the gender that is assigned at birth. Who is a transgender? Transgender is somebody whose gender does not match the gender assigned at birth. This bill also talks about right of residence. Normally we see that transgenders, they are discriminated in their families as well. There is a protection for these transgenders that you have the right of residence. You will have the right of residence where you are born. And if the household is not in a position to guarantee you your residence, then what can happen? The person may be placed in a rehabilitation center. Although you have the right of residence, but if the immediate family is unable to take care of a transgender person, then this transgender person may be placed in a rehabilitation center. One important thing regarding this bill is when the bill will be passed, it will create NCT, National Council for Transgender Persons. So you might be asked a question, which of the following or what is the composition of the proposed National Council for Transgender Persons? Because this NCT would become a statutory body, a body not created by the Constitution, but a body which is created by the Act of the Parliament. So this NCT would have Union Minister for Social Justice, who will be the chairperson of this NCT. Minister of State for Social Justice would be the vice chairperson. Secretary of the Ministry of Social Justice will also be part of it. Interestingly, one representative from Health Ministry, Home Ministry, as well as Human Resource Development Ministry. And at the same time, other members would include representatives of the Niti Aayog, National Human Rights Commission. State governments will also be represented. And the council will consist of 5 members from the transgender community, 5 experts from non-governmental organizations, NGOs. This composition becomes very, very important for your prelims 2020. But let's look at this transgender bill in slight detail. This is where you can expect a question. Some people say that this transgenders bill is against the NALSA judgment of 2014. What is this NALSA judgment? The year was 2014. Remarkably, in a landmark verdict, the Supreme Court said transgenders are to be recognized as a third gender. So this gender binary that we saw in our society, male, female, men, women, this gender binary was abolished, and in 2014, in a landmark verdict, the Supreme Court said transgender is a third gender. And the first constitutional body which respected the judgment of the court of 2014 was Election Commission of India. What Election Commission said? Prior to this judgment, a transgender person could also contest elections. But he or she could contest election only as either male or female. After this NALSA judgment of 2014, Election Commission said, if tomorrow a transgender person has to file for an election, you can register as a transgender as well. So that was thanks to this NALSA judgment of 2014. But important thing in this judgment was self-identification. Supreme Court said recognizing transgender as a third gender is not only a social issue, is not only an economic issue, it is a human rights issue. We are not going to be the deciders of whether you are transgender or not. You don't have to prove it. You just self-identify yourself that I'm a transgender. Don't associate me either as male or female. This self-identification is your right given by Supreme Court in 2014. This self-identification is being snatched by this transgenders bill. Why? Because transgenders bill, it says that district collector, district authorities will issue you a certificate, and this certificate will tell you whether you are transgender or not. So this self-identification, which was the right given by the Supreme Court in 2014, this transgenders bill violates that self-identification. That's number one. Number two, this NALSA judgment of 2014, it also said affirmative action policy. These transgenders, they should be provided reservation in government jobs and educational institutions because they have been discriminated against. Transgenders bill, it does not talk about this reservation at all. Another discrimination is being made. What is the discrimination? The bill says somebody who commits sexual violence against the transgender, he will be punished between the period of 6 months to 2 years. So if a transgender person is subjected to sexual violence, punishment will be given to the offender between 6 months to 2 years. When we compare this punishment to a punishment given out to an offender who sexually assaults a woman, the punishment for that individual is 7 years. So if you sexually harass or assault a woman, punishment is 7 years. But if you sexually harass a transgender, the punishment is only between the period of 6 months to 2 years. That's another discrimination. And on top of that, the bill says right of residence. That means this bill is forcing these transgenders to stay with their families. But families are often the first places of violence against transgender community. So this right of residence was not required at all. That's what the transgender community is protesting against the provisions of this bill. And all these provisions are very important for your prelims 2020. Let's look at another question. The Surrogacy Bill 2019. India was fast emerging as the surrogacy capital of the world. But now, if this surrogacy bill is passed by the parliament, because this bill has been passed by Lok Sabha, it is now pending in the Rajya Sabha. A select committee of Rajya Sabha is examining the various provisions of this surrogacy bill. This surrogacy bill, what it says, commercial surrogacy is prohibited. It only allows altruistic surrogacy. That means only for good purpose, surrogacy is allowed, but not for commercial purposes. So if India was fast emerging as the surrogacy capital of the world, but that commercial surrogacy will now be abolished, the bill only allows altruistic surrogacy. What are the other provisions of this bill? Only the Indian citizens are eligible to opt for surrogacy, but these conditions are very important. You can expect a question on these provisions. The couple who is an Indian couple, citizens of India, and who have been married for 5 years, only those are eligible to opt for surrogacy. There is a report by Select Committee of Rajya Sabha. It says, why should a couple wait for 5 years to opt for surrogacy? This waiting period of 5 years of married life should be done away with. But we don't know whether that recommendation of Rajya Sabha Select Committee would be accepted or not. But as of now, the provision is an Indian couple, that means foreigners are not involved, an Indian couple married for 5 years, they are eligible for surrogacy. Number 2, the age of the wife should be between 22 to 50 years, very important. Age of the husband between 26 to 55 years. Only then you are eligible for surrogacy. They do not need to have any surviving child. That means if there is an Indian family who have been married for 5 years, they belong to this age group, but they don't have any surviving child. Only this family is able for surrogacy, is eligible for surrogacy. But there is one thing which is deeply concerning because of this bill. And the bill says, if this married couple has a surviving child, but this surviving child is mentally or physically challenged, even then you are eligible for surrogacy. That means if there is a family, an Indian family married for 5 years, they do not have a surviving child, you are eligible for surrogacy. Even if you have a child who is surviving, but this child is mentally disadvantaged or physically disadvantaged, even then you are eligible for surrogacy. Critics say, after the surrogacy, when the child will be born, don't you think this family will discriminate against this physically and mentally challenged child? That is why some people, they are criticizing this bill. But nevertheless, this is part of the provisions of the bill, can be important for your prelims examination. Let's look at something else. To obtain the certificate of eligibility, the surrogate mother has to be. Now there is this couple who will opt for surrogacy, but who is going to be the surrogate mother? The surrogate mother has to be the close relative of the intending couple. But who is this close relative? We don't know. But she has to be the close relative. She should be married woman, having the child of her own. If you are not married, you don't have a child, which basically means you cannot act as the surrogate mother. This surrogate mother should be between 25 to 35 years old. Another provision. A surrogate only once in her lifetime. That means if you are acting as the surrogate mother, you can act only once in your lifetime, not the second time, not the multiple times. Very important provisions can be asked in your examination. One last point, very important. The surrogate mother cannot provide her own gametes for surrogacy. That is something which is not allowed by this surrogacy bill. Let's look at something else. A child born out of surrogacy procedure will be deemed to be the biological child of the intending couple. That means surrogate mother will not be the legal mother of the child. The legal parent of the child would be the intending couple. And at the same time, if abortion is to be carried out, abortion of the surrogate child requires the written consent of the surrogate mother. Without the permission, without the written consent of the surrogate mother, abortion cannot be prescribed, cannot be carried out. Let's look at various schedules of the Constitution can be important for your prelims examination. Schedule 1, it talks about the names of the states and union territories in India. So all these 28 states and 8 union territories that we have, their names are mentioned. Where? Schedule 1 of the Constitution. Schedule 2 of the Constitution, it talks about salaries of various constitutional functionaries. So in match the following types of questions, this schedule can be very important for your examination. Schedule 3 talks about oath or affirmation. Schedule 4 talks about representation of states in Rajya Sabha. That means there are 31 MPs from Uttar Pradesh in the Rajya Sabha. Where is it mentioned? It is mentioned in Schedule 4 of the Constitution. But why is schedule in the news? In the news? Because of Schedule 5, Schedule 6. Why? Because of the scheduled tribal areas. Because of the Bodo Accord that we saw last year. What is Schedule 5? Schedule 5 talks about the administration of tribal area in states other than Assam, Meghalaya, Mizoram, and Tripura. That means Schedule 5 talks about the administration of tribal areas. Where? In states other than Assam, Meghalaya, Mizoram, and Tripura. Why are these 4 states excluded? Because these 4 states are specifically mentioned under Schedule 6 of the Constitution. That is why they are excluded from Schedule 5. Similarly, Schedule 7 talks about union list, state list, concurrent list. Schedule 8, it talks about 22 languages. Now, interesting thing is, what is Schedule 9 of the Constitution and what is Schedule 10 of the Constitution? And I'll tell you how Schedule 10 is in the news. Schedule 9 talks about all those laws which are placed in 9th schedule, they are immune from judicial review. Schedule 9 was not originally part of the Constitution. It was added to the Constitution by the first Constitutional Amendment Act. The year was 1951. All those laws which are placed in 9th schedule, they are immune from judicial review. But then came 24th April 1973. What happened on 24th April 1973? A landmark verdict, Keshavananda Bharti versus State of Kerala, was announced by the Supreme Court. And it was in this judgment that Supreme Court said judicial review is part of the basic structure of Indian Constitution. Now the question is, what happens to those laws which are placed in 9th schedule? Will these laws come under judicial review or not? For that, there are 2 judgments which were in the news. Judgment 1, Vaman Rao judgment. Judgment number 2, IR Kolo versus State of Tamil Nadu, 2017. Both these judgments said all those laws placed in 9th schedule till 24th April 1973, there won't be any judicial review. But all those laws which are placed in 9th schedule after 24th April 1973, there will be judicial review. And now Schedule 10 of the Constitution. And Schedule 10 talks about anti-defection law. And surely you should expect a question on anti-defection law, because what happened in Karnataka, what happened in Madhya Pradesh, what happened in Rajasthan, anti-defection law is in the news. What is this anti-defection law? Let's look at the provisions very briefly. Provision number 1, let's say for example, I am a member of a legislature. I belong to a political party. If I voluntarily resign from that political party, I will be disqualified under anti-defection law. I am a member of the legislature, whether it is Lok Sabha or Rajya Sabha, State Legislative Assembly or Legislative Council, doesn't matter. I am the member of the legislature. I belong to a political party. If I voluntarily resign from that party, I will be disqualified under anti-defection law. This is provision number 1. Provision number 2 is, if I am an independent member of the legislature, I was not set up by any political party, I contested the election as an independent candidate and I won the election. When I won this election, I am an independent member of the legislature. Now, if I join the political party after my election, I will be disqualified under anti-defection law. Third, if I am a nominated member of Rajya Sabha, because 12 MPs can be nominated by the President to Rajya Sabha from the fields of art, literature, science, social service, I have 6 months. Within 6 months, I as the nominated member can decide whether I want to join BJP or the Congress or Aam Aadmi Party. But if I join a political party 6 months after my nomination, I will be disqualified under anti-defection law. And the last important provision is, if you violate the whip issued by the political party. Yesterday we discussed that there is something called Rajya Sabha election where there is open ballot. Let's say for example, in Rajasthan, Ashok Gehlot decided that I will introduce a confidence motion. I will prove that I have the majority on the floor of the Legislative Assembly. In that case, if a whip was issued to the Congress MLAs that you have to participate in this vote of confidence and you have to vote in favor of Ashok Gehlot, if any Congress MLA would violate this whip, he will be disqualified under anti-defection law. But interesting thing here is this statement. What is the statement? When in Karnataka, 17 legislators, they resigned, they were disqualified by the speaker under anti-defection law, but they were disqualified for the remainder of the term as well. This is where an important concept can be asked in your prelims examination. Let's say for example, who gets to decide whether you should be disqualified under anti-defection law or not? The speaker. The speaker of Lok Sabha, the speaker of Legislative Assembly, the chairperson of Rajya Sabha, the chairperson of Legislative Council, they get to decide whether a legislator should be disqualified under anti-defection law or not. But then the speaker of Karnataka Legislative Assembly did something spectacular. What he said, that all these 17 MLAs, they are disqualified under anti-defection law and they are barred from contesting the election for the remainder of the term. That means the term of an MLA is 5 years. If after 1 year you are disqualified under anti-defection law, Karnataka speaker said for 4 years you should also not contest elections. That means you are barred from contesting the election. Is this something mentioned in 10th schedule? Is this something mentioned under anti-defection law? No. Matter went to the Supreme Court. Supreme Court said no. That is something that you cannot do. That means even if they are resigning, even if they are disqualified under anti-defection law, but that does not bar them from contesting the elections again. Even if you are disqualifying them, let them go back to the electorate. And if the electorate wants, they will get re-elected. And then these 17 MLAs, these MLAs who resigned, they contested the election again, and 16 of them won the election again. So that is why anti-defection law is in the news, and definitely you can expect a question on anti-defection law. Let's look at another interesting thing, and that is part of your current affairs. The United Nations Human Rights Committee has reaffirmed that protesting peacefully, whether online or in person, it is a fundamental human right. This statement is correct. But what is the role of this committee? What is the role of this United Nations Human Rights Committee? This committee monitors the countries whether these countries are implementing International Covenant on Civil and Political Rights, ICCPR. This committee monitors whether the countries, whether the states, they are implementing this convention or not. Because it is this convention, under Article 21 of this convention guarantees a right to peaceful assembly. And now United Nations Human Rights Committee, it has reaffirmed that protesting, whether online or in person, is a fundamental human right. Both these statements are correct. Statement number 3, the committee has stressed that peaceful protesters, they have the right to wear masks or hoods to cover their face as well. Even this statement is correct. So which are the correct options? D. All these statements are correct. Let's look at another question. India is said to be a republican nation. Which of the following is the correct meaning of this? Statement 1, foreign nations cannot influence India's decisions with regard to security. But that is something that we call sovereignty, not the republican nation. This statement is wrong. No religion in India is special to the state. That is something that we call secularism. So this statement is incorrect. Concentration of wealth in fewer hands is prohibited. That is what we call socialism. So this statement is incorrect. Head of the state is elected by the people. That's what a republican nature of Indian Constitution talks about. So republic character says head of the state is an elected individual. Head of the state is not a hereditary position. Head of the state is not a monarch. That is why England. Is England a democracy? Yes. Is England a republic state? No. We say that England or Great Britain is a constitutional monarchy. Why? Because the head of the state, the Queen, she is not elected by the people. She is holding a hereditary position. So republican nature says head of the state is elected by the people. Let's look at something else. Which of the following are part of the preamble to the Indian Constitution? Secular? Yes. Fraternity? Yes. Communism? Is it mentioned in the preamble? No. Equality? Is it mentioned in the preamble? Yes. Because there are 3 glorious lessons from French Revolution which have been made part of the preamble. Liberty, equality, fraternity. Brotherhood. Is brotherhood talked about in preamble? In preamble we talk about fraternity, not brotherhood. So this statement is not correct. So 1, 2, 4 is the correct answer. Where is it mentioned? C. C is the correct answer. Let's look at something else. Consider the following statements regarding Parliament's power to reorganize the states. Statement number 1, a bill contemplating reorganization of any state requires prior recommendation of the governor of the state before its introduction in the Parliament. Not the governor, the president. Incorrect. The law made for reorganizing the states is not considered to be a constitutional amendment act under Article 368. Absolutely correct. So which of the above statements are correct? Only 2B is the correct answer. Let's look at another question. Which of the following best describes citizenship? Very important question. If I was the question paper setter, I would include this question. Why? Because this is also slightly tricky. Tricky in the sense, you have to be absolutely sure what best defines citizenship. Last year, I think, there was a question asked, or last to last year, which of the best describes liberty? And the answer to that was, if there are no laws, there is no liberty. Why is this the answer to that question? Because this was the statement of John Locke. In his book on liberty, he wrote, if there are no laws, there is no liberty. The same manner, I will give you half a minute. Please answer this question. Which of the following best defines citizenship? And I'll tell you, the least option that you would expect, that would be the answer to this question. Statement number 1, a give and take where state confers rights on its citizens and citizens have duties towards the state. Is this citizenship? Maybe. Citizenship is the relationship that allows right to vote in the elections. Yes, only the citizens have the right to vote. But is it what citizenship is? Let's wait and watch. Citizenship is the guarantee of social and economic rights to the people. This is also citizenship. But the question says, which of the following best defines citizenship? And which of the following best defines citizenship? Option B. Citizenship is the right to have rights. And why is this statement correct? Because this is the definition of citizenship given by noted political theorist Hannah Arendt. Hannah Arendt writes, citizenship is basically the right to have the rights. And this statement B is the correct answer to this question. Let's look at something else. And while I'm teaching you, it suddenly hit me that today is the last polity class. So I have taken in total 4 sessions wherein I have tried to my level best to revise Indian polity or current affairs related to Indian polity for you. It suddenly hit me that today is the last class and I'm surely going to miss all of you. And hopefully I have been able to deliver to the best of my capability, and hopefully you can expect majority of the questions in polity in this year's prelims from whatever we have discussed in the last 4 classes. But I'll miss you. And on top of that, I got an email from one of our students. And the student asked, sir, do you check the comments that people write below your videos? Yes, I do. I make it a point that I check all these comments that people make on our videos. And the student asked, how do you feel after reading all these comments? And to be very honest, I feel humbled. It gives me a sense of responsibility. And the moment I read all these comments, I am overwhelmed by all the love and affection that you give to us. And today also, since this is the last class, I will make sure that I will read all your comments, all your favorite positive, negative comments as well. So please tell me after the session is over, how do you feel about these live classes? And how do you specifically feel about these 4 polity lectures that I have taken? Please send in your comments, positive, negative, anything. And today I will make it a point that throughout the night, I won't sleep, I will only read your comments. So please do that. And if you're liking these initiatives, again, pay for us so that you don't have to be grateful to us. So there are 6,651 students who are watching the class right now. Out of these, how many people are liking this initiative? Please like this video so that we can get to know. Let's get started and look into this question. Which of the following committees or commissions recommended reorganization of states on linguistic basis? Was it Dar Commission? Dar Commission of 1948. It did not recommend reorganization of the country on linguistic lines. Was it JVP Committee? JVP stands for Jawaharlal Nehru, Sardar Vallabhbhai Patel, Patabi Sitaramaya. They did not also recommend reorganization of the country on linguistic lines. But was it Fazal Ali Commission? Yes. And Fazal Ali Commission is basically States Reorganization Commission, headed by Fazal Ali, H.N. Kunzru, K.M. Panikkar. They recommended reorganization of the country on linguistic basis. So C, 3 only, is the correct answer. Let's look at another important question. Article 13 of the Constitution says any law which is inconsistent with any of the fundamental rights shall be void. But what is the definition of this law? The definition of this law is provided under Article 13, Clause 3 of the Constitution. And which is this law which cannot violate a fundamental right? Ordinance, it cannot. Bylaw, it cannot. Customs, it cannot. But a Constitutional Amendment Act can violate a fundamental right. That is why we say only a Constitutional Amendment Bill, only a Constitutional Amendment Act can delete a fundamental right, can modify a fundamental right, can abridge a fundamental right. But an ordinance, bylaw, customs and usages, they cannot violate the fundamental rights. 1, 2, 4, what is the correct answer? C is the correct answer. And this is where I want to correct myself as well. I think in my second session, when we discussed ordinance, I told you what is the maximum validity of an ordinance. I said the maximum validity of the ordinance is 6 months and 6 weeks. So 7.5 months. But erroneously, I wrote 6 months and 4 weeks. That's incorrect. I'm sorry for that. But the correct answer is the maximum validity of an ordinance is 6 months and 6 weeks, which is 7.5 months. Let's look at another question. Article 17 provides for right against untouchability, but the Constitution does not define untouchability. Absolutely correct. Untouchability is not defined in the Constitution under Article 17. Right against untouchability under Article 17 is an absolute fundamental right. Is it an absolute fundamental right? Yes. Now, what is an absolute fundamental right? Which comes with no exceptions. For example, Article 19, it says freedom of speech and expression. But it says that freedom of speech and expression is not absolute. On 8 grounds, your freedom of speech and expression can be restricted. Sovereignty of India, security of the state, friendly relations with foreign countries, public order, contempt of court, incitement to violence, defamation. There are 8 grounds. Morality or decency. There are 8 grounds on the basis of which your freedom of speech and expression can be restricted. But if there is a fundamental right which is absolute, which comes with no restrictions, that's Article 17. Article 17 is self-executory. No. Which of the above statements are correct? B, 1 and 2 only. What do we mean by self-executory fundamental right? Let's say, for example, Article 14 is self-executory. You don't have to make a law to implement equality in this country. All laws have to be equal. That is what Article 14 says. Equality before law, equal protection of the laws. But you don't have to create a law, enact a law to implement Article 14. But to implement Article 17, you have to pass a law because Article 17 is not self-executory. And that is why we have Atrocities Act. That is why we have Protection of Civil Rights Act to implement Article 17 of the Constitution. Let's look at another question. Because of Sabrimala case, because of various Supreme Court judgments, this freedom of religion becomes important. In the context of right to freedom of religion, which of the following statements are correct? Conversion of a person into another religion is not a fundamental right. Yes. What is freedom of religion? Freedom of conscience and freedom to profess, practice and propagate your religion. That's your fundamental right. But when you propagate your religion, that does not give you the fundamental right to convert others into your religion. That's what Supreme Court said in the year 1977. Reverend Father Stanislaus versus State of Madhya Pradesh, 1977. Supreme Court said, you have the freedom of religion as your fundamental right, but the freedom of religion does not give you the fundamental right to convert others into your religion. So the statement conversion of a person into another religion is not a fundamental right. This statement is correct. It's not your fundamental right. The state can impose reasonable restrictions on your freedom of religion for protecting the sovereignty of India. No. What are the restrictions on your freedom of religion? Freedom of religion also is not an absolute fundamental right. There can be restrictions imposed on your freedom of religion. But on what grounds? On the grounds of health, on the grounds of morality, on the grounds of public order. These are the three grounds on the basis of which restrictions can be imposed on your freedom of religion. In the name of sovereignty of India, there can be no restrictions on your fundamental right to the freedom of religion. So which of the above is the correct answer? Only one, A only is the correct answer. Right to freedom of religion includes freedom of conscience, yes. Declaration of one's religious beliefs openly, that's freedom of profession, yes. Perform religious rituals, absolutely yes. Dissemination of one's religious beliefs to others, that is freedom to propagate your religion. Even this is your fundamental right. That means which of the above statements are correct? D. 1, 2, 3, 4. All these statements are correct. Let's look at another question. The Constitution under Article 20 provides that no person shall be prosecuted and punished for the same offense more than once. And that is what we call in United States double jeopardy. And what is this double jeopardy? No person shall be convicted for the same offense more than once. This protection is available in which of the following cases? Proceedings before a court of law? Yes. Proceedings before a tribunal? Yes. Proceedings before the administrative authorities? No. Which of the above statements are correct? B. 1 and 2 only. There are three important fundamental rights under Article 20. One is Article 20 Clause 1. What it does? It prohibits the legislature. What the legislature, what the parliament cannot do, it cannot enact a criminal law and give it a retrospective effect. That is what we call in United States ex post facto criminal legislation. That means parliament cannot create a criminal law, enact a criminal law and give it a retrospective effect. The effect to a criminal law has to be prospective. This criminal law must come into force from a later date, not from an earlier date. That means 20 Clause 1 imposes a restriction on the legislature. 20 Clause 2, that's what we call double jeopardy, it is a restriction on the judiciary. That means judiciary cannot prosecute someone more than once. That means judiciary cannot prosecute an individual for the same offense more than once. Which are the judicial institutions here? Proceedings before a court of law, it is a judicial institution. Proceedings before a tribunal, it is a judicial institution. Proceedings before an administrative authority, it is not a judicial institution. That means double jeopardy does not apply to it. Then what is the correct answer? B. 1 and 2 only. Let's look at another question. The Chief Minister of a state in India is not eligible to vote in the presidential elections if. Why is this question important? Uddhav Thackeray. Uddhav Thackeray, he was in limbo. Limbo in the sense, he became a surprise chief minister. He did not expect that he would become the chief minister, but three parties came together, Shiva Sena, Congress, NCP, and they declared Uddhav Thackeray would become the chief minister. But he was not a member of Legislative Assembly. He was not even a member of Legislative Council. And because of COVID-19 pandemic, even Legislative Council elections could not take place initially in Maharashtra. And there is a constitutional provision that a chief minister, he or she need not be the member of the legislature to become a chief minister. But within 6 months, Mr. Uddhav Thackeray had to be elected to either Legislative Assembly or Legislative Council. That is why chief minister is in the news. And that is why this question. The chief minister of a state in India is not eligible to vote in presidential elections if he himself is a candidate. No. He is a member of the upper house of the state legislature. Let's see. He is yet to prove his majority on the floor of the state legislative assembly. No. He is a caretaker chief minister. No. This B is the correct answer. Because what is the electoral college for president? In presidential election, electoral college consists of elected members of both houses of the Indian Parliament and the elected members of legislative assemblies. Here we are talking about upper house of state legislature, which is Legislative Council. The members of the Legislative Council, they do not participate in the election of the President of India. He is not a member of the Electoral College. That means he is not eligible to vote in the presidential elections. Let's look at something else. Electoral reforms, something that we discussed yesterday as well, wherein we talked about electoral bonds. Dinesh Goswami committee was concerned with A, electoral reforms. Let's look at another question. Consider the following statements. The minimum age prescribed for any person to be a member of panchayat is 25 years. No. Minimum age is 21, not 25. A panchayat reconstituted after premature dissolution continues only for the remainder period. Yes. What is the term of panchayat? 5 years. Even before 5 years, it can be dissolved? Yes. If it is dissolved, then there will be fresh election. What will be the term of this newly constituted panchayat? Another 5 years? Or for the remainder of the term? Only for the remainder of the term. So which of the above statements are correct? Only two. B is the correct answer. Let's look at Vice President of India. Very briefly, Vice President is in the news. What sort of questions can be asked? Vice President is also elected, but not directly by the people, indirectly. Indirectly by Electoral College. So if Pranab Mukherjee, former president, expired, if UPSC won't ask you about president, they will definitely ask you about the vice president. Let's briefly look at vice president. Vice president is also elected by the people, but not directly, indirectly, through the representatives in the Electoral College. But here the Electoral College changes. The Electoral College for the president is elected members of both houses of Indian Parliament, elected members of state legislative assemblies, elected members of the state legislative assemblies of Delhi and Puducherry as well. Delhi and Puducherry, despite the fact that they are union territories, they are not states, but their elected MLAs also participate in the election of the President of India. But for the Vice President, Electoral College consists of members of both houses of the Parliament. When we say members, that means elected as well as nominated. Nominated members of Rajya Sabha, they do not participate in the presidential election, but they participate in the vice presidential election. Because in vice presidential election, members of both houses of the Indian Parliament, whether elected or nominated, they are part of the Electoral College. They participate in the election of the Vice President of India. But Vice President can also be removed. The only thing that you need to remember is there are no grounds mentioned in the Constitution on the basis of which Vice President is to be removed from his office. On what grounds is the President removed from his office? The removal of President, the term we use for it is impeachment. And please understand, impeachment is the term that we use only for the President of India. Only the President is impeached. Chief Justice of India, Chief Election Commissioner, CAG, all these are removed. They are not impeached. Impeachment is the term only used for the President of India. President is impeached on what grounds? On the grounds of violation of the Constitution. But this term, violation of the Constitution, is not mentioned in the Constitution. So Constitution does not define what is this violation of the Constitution. But there are no grounds mentioned in the Constitution which are mentioned for the removal of the Vice President of India. No grounds are mentioned. That's very important for your exam. Let's look at another concept, joint sitting of both houses of the Indian Parliament. Because when we discussed Constitutional Amendment Bill, therein I told you that a Constitutional Amendment Bill needs to be passed by both houses of the Indian Parliament separately. That means there is no concept of joint sitting of two houses when it comes to constitutional amendment. But then where is this joint sitting of the two houses employed? Whenever there is a deadlock, let's say on an ordinary bill, we can go for joint sitting of Indian Parliament. Can we go for joint sitting of Indian Parliament in case of a money bill? No. Can we go for a joint sitting of Indian Parliament if it is a financial bill? Yes. On a financial bill, if there is a deadlock, then we can have a joint sitting of Indian Parliament, which means both houses of the Indian Parliament, they will come together and pass a particular bill. Interesting thing here is, and this is very important for your prelims, if at all this question is asked, this question will be asked. Who presides over the joint sitting of the two houses? That means Rajya Sabha members are also present. Lok Sabha members are also present. Normally Rajya Sabha is presided over by Vice President, the chairperson of Rajya Sabha. Lok Sabha is presided over by Speaker, the Speaker of the Lok Sabha. Now there is joint sitting of two houses. Both Rajya Sabha, Lok Sabha members come together. Who will preside over this joint sitting of two houses? Speaker. Speaker will preside over this joint sitting. If the Speaker is not present, then who? Deputy Speaker. And why are we discussing this? Because right now, there is no Deputy Speaker of Lok Sabha. That is why the Speaker of Lok Sabha, Mr. Om Birla, he was asked that we should have election for the Deputy Speaker. Just like we are having election for the Deputy Chairperson in Rajya Sabha, we should have elections for Deputy Speaker as well. That means in this second term of Prime Minister Modi, in this Lok Sabha, we don't have a Deputy Speaker yet. So Deputy Speaker becomes important. Interesting thing about Deputy Speaker is, there is a convention that we follow. And what is this convention? Convention, unwritten rule, not mentioned anywhere, but something that we follow. And what is the convention? The Speaker of Lok Sabha is always from the ruling party. The Speaker of the Lok Sabha is always from the ruling coalition. But the convention is that the Deputy Speaker is from the opposition. That is why in the last Lok Sabha, Mr. Thambudarai from AIADMK was the Deputy Speaker of Lok Sabha. So the convention that we are following is that Deputy Speaker is from the opposition. But this is only a convention, not mentioned in the Constitution, but something that we follow. And right now, we do not have a Deputy Speaker. That is why on Deputy Speaker, you might expect a question. Interesting thing about Deputy Speaker is, whenever Deputy Speaker is appointed to a committee, nominated to a committee, he or she becomes the chairperson of that committee. I'll repeat this again. There is one privilege that Deputy Speaker has. And once you are elected as the Deputy Speaker, because there is election to Deputy Speaker, whenever Deputy Speaker is appointed to a committee of the Parliament, he or she invariably becomes the chairperson of that committee. That's the privilege of a Deputy Speaker. Can be asked in your examination because we do not have a Deputy Speaker. So this joint sitting of two houses, who presides over this joint sitting? Speaker. But if the Speaker is not present, then Deputy Speaker. If the Deputy Speaker is not present, then who? Deputy Chairperson of Rajya Sabha. What if Deputy Chairperson is not present? Then any member who is chosen at this joint sitting of two houses, this particular gentleman, gentlewoman, this particular member presides over this joint sitting, which makes it interesting. Under no circumstance can the Vice President of India, the chairperson of Rajya Sabha, preside over this joint sitting of two houses. Now you want to know the reason? Why is that Vice President, the chairperson of Rajya Sabha, cannot preside over this joint sitting? Because Vice President is not the member of the Parliament. Speaker is the member of the Parliament. Deputy Speaker is the member of the Parliament. Deputy Chairperson of Rajya Sabha is the member of Rajya Sabha. That is why they can preside over this joint sitting of two houses, since Vice President, the Chairperson of Rajya Sabha, is not the member of Rajya Sabha, is not the member of the Parliament. That is why he or she does not preside over this joint sitting. That is why when we say Vice President is the chairperson of Rajya Sabha, this statement is half correct. Vice President of India is the ex officio chairperson of Rajya Sabha. Ex officio in the sense, by virtue of him holding the office of Vice President, he becomes the chairperson of Rajya Sabha. This question can be asked in your prelims examination. Let's look at something else. Adjournment. What is adjournment? Adjournment is brief interval in an ongoing session. What is a session? Important question, because right now the session of the Indian Parliament has been delayed because of the COVID-19 pandemic. You may be asked, is it that Constitution mentions what is budget session, monsoon session, winter session? No. Constitution does not talk about what is a budget session, monsoon session, winter session. Constitution has only one requirement. Constitution says Parliament should meet in such a manner that the distance or the time frame between the first session and the second session should not be more than 6 months. Constitution says that Parliament should be convened in such a manner that the time frame between the first session and the second session should not exceed 6 months. That's the only constitutional requirement that Constitution places on the convening of the Parliament. But then the rules of Parliament talk about budget session, monsoon session, winter session. And when the session is going on, there can be adjournment. And what is this adjournment? Adjournment is the brief interval, but in an ongoing session. What is this brief interval? Parliament is convened. Suddenly a member of the Parliament is raising hue and cry, is throwing chairs at each other, mic at each other, creating ruckus in the Parliament. What the Speaker will do? The Speaker will adjourn the House. The House is adjourned. We will meet tomorrow 10 o'clock in the morning. Adjournment does not end the session. It's only a brief interval in an ongoing session. Remember this carefully. Then what is prorogation? It is this prorogation which terminates the session of the Parliament. Where is this important? Please look at this carefully. The power to adjourn the House is with the presiding officer. Whether it is the Speaker, Deputy Chairperson, whatever. The power to adjourn the House is with the presiding officer. The power to summon the Parliament is with the President. The power to summon the state legislature is with the Governor. The power to terminate the session of Indian Parliament is with the President. The power to terminate the session of state legislature is with the Governor. That is something that we call prorogation. And then there is something that is called dissolution, when Parliament is to be dissolved. Is it a correct statement to make that Parliament is to be dissolved? Wrong. Parliament is not dissolved. What is dissolved is Lok Sabha. Because Rajya Sabha is the permanent house of Indian Parliament, it is not subject to dissolution. So it is not correct to say that Parliament is to be dissolved. Lok Sabha is to be dissolved. But in this dissolution of Lok Sabha, please remember 4 points very clearly. 4 important points. You might expect a question on this. When Lok Sabha is to be dissolved, there are 3 kinds of bills which do not lapse. This is a very important question, I think can be asked. My gut says this question can be asked in your examination. When Lok Sabha is dissolved, which are these 3 kinds of bills which do not lapse upon the dissolution of Lok Sabha? Bill number 1, a bill which originates in Rajya Sabha, and is pending in Rajya Sabha as well. This bill does not lapse. Why? Because Rajya Sabha is the permanent house of Indian Parliament, not subject to dissolution. A bill originating in Rajya Sabha, pending in Rajya Sabha does not lapse upon the dissolution of Lok Sabha. Second, a bill which has been passed by both houses of the Indian Parliament, and this bill is awaiting the assent of the President. A bill is passed by both houses of the Indian Parliament it is waiting the permission, the signature of the President of India. This bill also does not lapse upon the dissolution of Lok Sabha. But you might say that what if President wants to send this bill back? What if President wants to send this bill back because he has the suspensive veto? In that case, President can send this bill back to Rajya Sabha because Rajya Sabha is not dissolved, Rajya Sabha is there. That means this bill, which is awaiting presidential assent, this bill also does not lapse upon the dissolution of Lok Sabha. And then there is third bill, which is this bill which does not lapse upon the dissolution of Lok Sabha, a bill on which there was a deadlock. And to resolve this deadlock, what is the concept? Joint sitting of both houses of Indian Parliament. A bill on which there was a deadlock. To resolve this deadlock, joint session of Indian Parliament has been notified by the President. This bill also does not lapse upon the dissolution of Lok Sabha. And there is fourth important thing, a resolution which calls for the removal of the judge of a Supreme Court or High Court. This resolution also does not lapse upon the dissolution of Lok Sabha. So this one resolution, these three bills, these are the only four things which do not lapse upon the dissolution of Lok Sabha. Let's look at something else. Confidence motion, no confidence motion because of, again, Rajasthan. What is this confidence motion? Constitution is clear that Chief Minister will remain in office as long as the Council of Ministers command majority in Legislative Assembly. Constitution is clear that Prime Minister will continue to hold office as long as the Council of Ministers command majority in Lok Sabha. How do you prove that you have the majority in Legislative Assembly? How do you prove that you have the majority on the floor of the Lok Sabha? That is what we call floor test. And one tool of a floor test is confidence motion. This confidence motion is introduced by Prime Minister or the Chief Minister. Let's not wait for the opposition. Let me prove it on my own that I have the majority on the floor of Lok Sabha if I'm the Prime Minister. I have the majority on the floor of the Legislative Assembly if I'm the Chief Minister. And if this confidence motion is passed, government survives. If this confidence motion is defeated, Chief Minister, Prime Minister has no other option but to resign. One important thing that you need to know, what is the majority required to pass this confidence motion or to defeat this confidence motion? That is simple majority. And what is the simple majority? Majority of the members, more than half of the members present and voting. But if confidence motion is introduced by the Prime Minister or the Chief Minister, no confidence motion is introduced by the opposition. This time the opposition is calling for a floor test. This time the opposition is introducing no confidence motion. And this no confidence motion should be signed by 50 MPs of Lok Sabha. 50 MPs of Lok Sabha, they have to write to the Speaker of Lok Sabha that we want to introduce a no confidence motion against the Prime Minister. If the Speaker accepts, then there is a discussion on this no confidence motion, and at the end of this no confidence motion, there is a vote. And if this no confidence motion is passed by simple majority, Prime Minister has no other option but to resign. If this vote of no confidence is defeated in Lok Sabha, Prime Minister survives, the Council of Ministers survives. And if no confidence motion, interesting point, if this no confidence motion has been introduced today, for 6 months, you cannot introduce it again. That means then you have a 6-month liberty. You are continuing as the Prime Minister or the Chief Minister. Let's look at something else, and this is breach of privilege. Again, because of Kangana Ranaut, again because of our favorite Arnab Goswami, this breach of privilege is in the news. And this breach of privilege, for that, let's look at the Committee of Privileges. What is the Committee of Privileges? Although time is running out, but still I'll tell you briefly about this privilege. Original Constitution it said that whether MPs, legislators should have privilege or not, for that, Parliament should pass a law. Remember this carefully, can be asked in your examination. Should MPs, should legislators have privileges or not? For that, Constitution said, let Parliament frame a law. But till the time Parliament frames a law, all those privileges that are available to British parliamentarians, those privileges will continue to have for Indian parliamentarians as well. That means so far as privileges are concerned, Constitution says till the time Parliament frames a law to codify all these privileges that are available to the members of the Parliament, to the Parliament as an institution, all those privileges that are available to British parliamentarians, they will continue. Then came 44th Constitutional Amendment Act. The year was 1978. This 44th Amendment entered into force on 20th June 1979. Interesting thing here is, Constitutional Amendment of 1978 said all those privileges which existed before this date, those privileges will continue. Which are the privileges which existed before 20th June 1979? British privileges. Those privileges will continue. That means the only thing that this 44th Amendment did, it dropped the reference to British Parliament. That means even now, the privileges that we have, they are the privileges that are available to British parliamentarians. That's statement number one. Very important statement for your prelims exam, because there is no law which has been passed yet to codify all these privileges that are available to members of the Parliament. Two important statements. Number one, all those privileges which are available for British parliamentarians, they continue in India. And number two, there is no law which codifies all these privileges. And for that, we have Privileges Committee. Please remember this carefully. There is a Privileges Committee in Lok Sabha as well. There is a Privileges Committee in Rajya Sabha as well. The Privileges Committee of Lok Sabha consists of 15 members. And all these 15 members are nominated by the Speaker. Clear? But so far as Privileges Committee of Rajya Sabha is concerned, it consists of 10 members. And these 10 members are nominated by the chairperson of Rajya Sabha. That is something very, very important for your prelims examination. Last thing, Panchayati Raj institutions. And there was this controversy in Andhra Pradesh. Andhra Pradesh governor promulgated an ordinance. And because of that ordinance, the term of State Election Commissioner was cut short, and effectively he was removed from his office. Panchayati Raj, number one. Are Panchayati Raj institutions created in the states based on the law passed by the Parliament or based on the provisions of the Constitution? Please understand, 11th schedule of the Constitution talks about Panchayat. 12th schedule of the Constitution talks about municipalities. All these Panchayati Raj institutions are created by the law of the state legislature. So Karnataka will create a law and set up Panchayati Raj institution. Andhra Pradesh will create a law and set up Panchayati Raj institutions in Andhra Pradesh. But whenever Andhra, Karnataka, all these states, they have to set up Panchayati Raj institutions. They have to follow the Constitution. Because 73rd Amendment gave constitutional status to Panchayati Raj institutions. 74th Amendment gave constitutional status to municipalities. But for that, elections are to be conducted. And for that, special body was created by the Constitution. And that is what we call State Election Commission. This State Election Commission, number one, is a single member body. It consists of State Election Commissioner. This State Election Commissioner is appointed by the governor. And Constitution says this State Election Commissioner, who is appointed by the governor, he can be removed just like the judge of a high court is removed. You tell me, how is the judge of a high court removed? The judge of a high court is removed by the President of India based on the resolution passed by both houses of the Indian Parliament, that too by special majority. Then how was it that the State Election Commissioner in Andhra Pradesh, he was removed? Please understand this carefully. Number one, Constitution says yes, a State Election Commissioner can be appointed, is appointed by the governor, can be removed in the same manner as the judge of a high court, or whatever conditions are decided by the law passed by the state legislature. So the state legislature has the right to create a law to define the conditions of service for this state election commissioner. But interesting thing here is, his conditions of service cannot be varied to his disadvantage after his appointment. So when the state election commissioner was appointed in Andhra Pradesh, then he got into tussle with Jagan Mohan Reddy, the Chief Minister of Andhra Pradesh. Chief Minister asked him, please organize, hold an election for local bodies. He said there is COVID-19 pandemic. In this case, there will be transmission of the disease. So I will not conduct the election. Then an ordinance was promulgated. And the term of state election commissioner, which was 5 years, the ordinance said the term is now 3 years. Since the state election commissioner, Mr. Ramesh Kumar, he had already completed 3 years, effectively it would mean that your term is reduced from 5 to 3 years. That means you are out of the office. The High Court of Andhra Pradesh said this is wrong. You cannot vary the conditions of service of a state election commissioner after his appointment. And that is how he was reinstated, and Mr. Ramesh Kumar continues as the State Election Commissioner of Andhra Pradesh. So State Election Commissioner can be important question for your prelims examination. I told you that we will discuss NCBC, National Commission for Backward Classes as well, because 102nd Constitutional Amendment Act created National Commission for Backward Classes. NCBC is a statutory body created by an Act of Parliament in the year 1993. No, it was a statutory body. It was created in 1993. But last year, it was given a constitutional status. So this statement is wrong. The commission consists of chairperson, vice chairperson, and 3 other members. Correct? The chairperson will be in the rank and pay of a cabinet minister, while the members will be in the rank and pay of Minister of State. Incorrect. The chairperson and the members will be in the rank and pay of Secretary to Government of India. So statement 1 is incorrect. Statement 3 is incorrect. What is the question asking you? The question is asking you which of the above statements are incorrect. Statement 1 is incorrect. Statement 3 is incorrect. C, 1 and 3 is the correct answer. I'll take few more minutes. I know it is 9:30, but please stay with me. We are coming up with something very important. I will be fast so that we are finishing on time, but please stay with us. The name of the director of the CBI. CBI is in the news because of Riya Chakraborty, Sushant Singh Rajput again, and CBI was in controversy throughout this year as well. Let's not get into why it was in controversy. Let's look at the question. The name of the director of CBI is cleared by the committee led by Prime Minister, comprising the Chief Justice of India and leader of the opposition in Lok Sabha. A high-powered committee consisting of Prime Minister, Chief Justice of India, or somebody nominated by Chief Justice of India and leader of opposition in Lok Sabha. This committee, this high-powered committee, clears the name of the director of CBI, and the director of the CBI has a tenure of 2 years. So which of the above statements are correct? C. Both these statements are correct. Let's look at NIA. National Investigation Agency was constituted under the National Investigation Agency Act of 2018. Constituted in 2008 in the aftermath of the terrible 26/11 attacks in Mumbai. So it was in that backdrop that NIA was set up. Second, it is a central agency to investigate and prosecute offenses related to terrorism, but does not have the mandate to investigate the smuggling of high quality counterfeit Indian currency. This statement is wrong. It is a central agency to investigate and prosecute offenses related to terrorism. It also has the mandate to investigate the smuggling of high quality counterfeit Indian currency or high value counterfeit Indian currency. Statement number 3, NIA implements international treaties, agreements, conventions, and resolutions of United Nations, its agencies, and the international organizations. Yes, this statement is correct. But the question is asking you, which of the above statement is or are incorrect? So statement 1 and 2 are incorrect. B is the correct answer. Let's look at another question. The Constituent Assembly was created under the scheme formulated by which of the following authors? Was it August offer? No. Was it Cripps proposal? No. Was it Dickey Bird plan? No. It was a cabinet mission plan. The year was 1946. Let's look at another question. Consider the following statements regarding the Act of British government. Why is this question important? Because we are saying that during COVID-19, the polity of India has transformed from a federal polity to a unitary one. There is more and more power given to the central government. That is why this question is very important. Which of these acts are we talking about? For the first time, this act recognized the political and administrative functions of the company. Which act are we talking about? For the first time, it was the founding stone for central administration in India, and it is this act which established the Supreme Court at Calcutta. Which act are we talking about? Regulating Act of 1773. Let's look at something else. Which one of the following was the source of governance for the independent India till the enactment of its own constitution? It is Government of India Act 1935. Let's look at few important facts related to national education policy. Number 1, important thing is, we were calling the Ministry of Human Resource Development. So we had no Ministry of Education, we had Ministry of HRD or MHRD, Ministry of Human Resource Development. NEP 2020, what it does, it renames MHRD, renames it as Ministry of Education. That is why if you log into the website of Education Ministry, it will be mentioned Ministry of Education instead of Ministry of Human Resource Development. This policy is based on pillars. You'll have to remember these pillars. These are the favorite words of Prime Minister Modi. Access, equity, quality, affordability, and at the same time, accountability as well. NEP 2020 is the first new education policy to be introduced, because when was the last time that a national education policy was set up? That was 34 years ago. The year was 1986. And this national education policy of 2020, the draft committee was headed by K. Kasturirangan, who was the former chairperson of ISRO, Indian Space Research Organization. Now look at the question. Goal of the NEP is to achieve 100% gross enrollment ratio in preschool to secondary level by 2030. Is this statement correct? You will have to mug up these facts, can be very important for your prelims. The NEP changes the existing 10+2 structure of school education to a 5+3+4, covering children between the age groups of 3 to 18, which is happening for the first time. That is why the statement is also correct. The medium of instruction. What is going to be the medium of instruction under national education policy? Till primary stage of education, it has to be mother tongue, it has to be home language, it has to be local language. But preferably, till 8th standard, it should be local language. All these statements are correct. D is the correct answer. The goal of NEP This is very important goal of the NEP. That is why it has been praised by all the political parties, cutting across political ideologies. The goal of the NEP is to increase gross enrollment ratio, where in higher education, including vocational education, currently the percentage is 26.3, and we want to increase it to 50%. But the year becomes important. By which year? And the year is 2035. Let's look at another question. If we are talking about Ministry of Education, we should also know which are these departments that come under Ministry of Education. Which of the following are the departments under Ministry of Education? Department of School Education and Literacy? Yes. Department of Higher Education? Yes. Department of Curriculum? No. Department of Early Childhood Care? No. There are only two departments under the Ministry of Education, and these are the two departments. Which is the correct answer? A, only 1 and 2. Which of the following is the final authority to deal with the disputes regarding the election of the president? C, Supreme Court is the final answer. Who among the following can participate in both the president and vice president elections? Elected members of state legislative assemblies, but they do not participate in the vice presidential election. Nominated members of Lok Sabha, but they do not participate in the presidential election. Elected members of Rajya Sabha, yes they do. Members of the state legislative councils, no they don't. Elected members of Puducherry Assembly, no. Then 3, C is the correct answer. Now there are two things important. One is office of profit, the other is sedition. These two things were also in the news, but the time does not permit us now. I think we will have to leave it here. Thank you for being with us throughout these 4 sessions. I thoroughly enjoyed all these 4 sessions. I don't know about you, but how do you feel about these 4 polity-based current affairs sessions? Please do let me know. Type in your comments, and I'm going to personally look at all these comments from you. And if you have liked these initiatives, if you have liked my classes, press the like button, subscribe to our channel if you haven't yet, and all the best for your examination. Don't worry, this is just like any other exam. And if you have cleared so many exams in your life, this is just another exam. Don't stress. If a question is difficult, that is difficult for every single aspirant, not just you. Have faith. If you have performed well throughout your preparation process, there is no power on earth that can stop you from clearing this examination. My best wishes to you. Please don't stress. And yes, press the bell icon. That's something notified to me. Press the bell icon so that you don't miss another update from us. And why? Most often we get this complaint that you have been live and we don't get the notification. That is not our problem. For that, you'll have to subscribe to the channel. Press the bell icon. When you press the bell icon, you will be notified whenever we upload a video, whenever we start with a live session. So if you want to be notified at every time, if at all, for that you'll have to subscribe and press the bell icon. Don't stress. All the best. Best of luck. Thank you for staying with us. Thank you for being with us. I thoroughly enjoyed all these 4 sessions. Hope to see you again when we will have a special batch for the mains aspirants who are going to write the mains examination. I'll see you there. Good night. All the best.